Thank you for checking in again, Cherry Fieger and Cherry. At Cherry Fieger and Cherry, we've handled thousands of workers' compensation claims over the year, positively affecting many lives. One of the most common questions is, what should I do if my claim is denied? And why has it been denied? Let's talk about why it was denied at first. Many times the insurance company adjuster and the employer don't have all the information they need to properly evaluate the claim in 21 days. If your claim is denied, getting an attorney can make the process a lot easier. You are allowed to represent yourself, but that process is often discouraged when you get into court because the process of handling the claim can be very complicated. For example, when you have a denied claim and you want to file a claim, you have to do it electronically through the Bureau of Workers' Compensation. Many people don't understand that process. In fact, our whole process is now going electronic. So every filing that you would need to make, taking depositions, writing briefs, that's all something that an experienced workers' compensation attorney, like here at Cherry Fieger and Cherry, can handle. And the common person who has a workers' compensation claim once or twice in their life doesn't understand. So there is a distinct advantage to having an attorney. During the first 45 days, the other side is going to have an opportunity to have you evaluated by their medical expert. They sometimes refer to this as an IME, or independent medical examination. I don't like to think of it that way because you don't really have any input on the doctor they select. So in that sense, it's not independent. I often refer to it as a DME, or defense medical examination, or a hired gun, somebody hired by the insurance company to say you're not injured. So once you get evaluated by their medical expert, we have to have our medical expert supporting your contention that you're injured and you're disabled from work. And many times it's difficult to find medical experts that will support your version of the case because you don't know who to treat with, you don't know who to go to, and it's our job to help you find people that if you can't find them. Many times the next question I often receive is, hey, the employer has, do I have to treat with their doctors? I've heard about this 90-day rule that during the first 90 days I have to treat with their doctors. The rule that they're referring to is under Section 306 of the Workers' Compensation Act. And the rule says essentially this: if your employer has a list of physicians, panel physicians, posted prominently at the place of employment, and you sign an acknowledgement acknowledging that if you're injured that you will go seek treatment from these doctors, then if you don't seek treatment with those doctors during the first 90 days, your employer reserves the right to contest the reasonableness and necessity of that treatment and essentially contest whether they have to pay that bill or not. My interpretation of the rule is this: this is America, and that you can treat with any doctor that you want at any period in time. Understanding, though, that if your employer has complied with the rules, has a list posted prominently of panel physicians at the place of employment, and that you sign an acknowledgement, then during those first 90 days, if you don't treat with those doctors, those bills might not be covered. But with that said, most of the employers don't have that list posted prominently, and I find that most of the time that is not an issue in court.